course it hasn't been done before because Parliament only created the instrument barely a year ago. So
No. This instrument was, you mean the directive? The directive on a specific prosecution has never occurred, and this happened because Harper brought this law in, as you probably know, 10 years ago. The directive the DPA has never been used because it just entered the criminal code back in September. So I understand that this is the first case. The prosecutor sent me what's called a Section 13. You told me that you hadn't seen it before, but I read it and I've reread it, and the Prime Minister's office has a copy of it. She explains in it why she's not doing it in this case. I have to be, unless it's something outrageous, comfortable with the decision, recognizing it's the first one, likely, and obviously I'm confident, wasn't entered into lightly, made the decision not to enter into a DPA with respect to this case. And she explained why.
So when did she convey that to you?
She issued the Section 13 back in September when I was down in Australia for whatever that, for the Five Eyes. And then all of this I have a timeline of every single conversation and everything that everybody's said to me on this. So I'm surprised that you and I are having this conversation, but I'm just saying that I really feel uncomfortable and about the appropriateness of this conversation.
Okay, I understand that, but I think his view is he's not asking you to do anything appropriate or to interfere. He's asking you to use all of the tools that you lawfully have at your disposal.
I know I have a tool under the Prosecution Act that I can use. I do not believe it is appropriate to use it in this case.
Okay. All right. Then that's clear. He's in a very firm mood about this. So
does he understand the gravity of what this potentially could mean? This is not just about saving jobs. This is about interfering with one of our fundamental institutions. This is like breaching a constitutional principle of prosecutorial independence. So I
don't think he sees it as that.
Well, then nobody's explaining that to him, Michael. Like this is we can stand up in the House of Commons and on Norman, on totally appropriately on Norman, on extradition, and we can talk about the rule of law. That the cases aren't dissimilar. The principle or the integrity of how we act and respond to the tools that we have available and what we should and shouldn't do. I don't know.
Okay. No, I respect where you're coming from. I just think...
you know what? I hope that you do, because I don't think anybody respects this. I mean, the conversation that Jerry and Katie had with my chief of staff, and I have it, like, she wrote down what they said, like saying that they don't want to have anything or hear any more about the legalities, but want to talk about jobs. Entirely inappropriate.
Okay, well, it wasn't...
Well, I have it all. It's just...
Okay, but you're not just the Attorney General, you're the Minister of Justice in the Cabinet, and that you have context within which you exercise your roles and responsibilities. Like, I'm not seeing anything inappropriate here, but you're right. No, and the PM, I think people are talking past each other. I think the way he sees it and the advice he's getting is that you still have things that you can do that are not interference and are still very much lawful. So
it's not that they're not lawful. The perception and what will happen is it will be deemed political interference from day one, when people were talking about why are we entering into or putting a DPA regime in place. Everybody knows it was because of SNC. Whether that's true or not, that's what people think.
It's a tool used in lots of other countries, though, for these kinds of purposes, and especially if there's been a change of ownership or management of the company that's being prosecuted. It is a public policy tool.
Fair, but in our MCs all the way up, and in the law that we changed,